Thank you so much. First of all, thank you to AusVeg for having us. This is our second year back at the convention, and it's fantastic to be here. So I'm just going to, it's a joint presentation, both myself and Russell are going to speak, and my background's more in IP, so I'm going to give a really broad overview of some monopoly rights that you guys might be interested in, and then Russell's going to have a chat about the R&D tax incentive. So when we're talking about intellectual property, we're talking about, patents, trademarks, plant breeders' rights, designs, and copyright. So today I'm just going to focus on the top three there. And a lot of people ask, why would I need something like that? And the field that we're in is all about creating an asset for you. It's an intangible asset, but nevertheless, it's an asset. And once you get a monopoly right for a patent or a trademark or something like that, you can actually invoke some premium pricing around your products. You can leverage your market position. And also, we have quite a few clients who just utilise them to deter competitors. So they might have a patent portfolio and they've really carved out an area in their space just to deter competitors. But at the end of the day, it's all about a currency. And once you get something like a patent or a trademark registered, you can then go and license it or sell that. If you wanted to sell your company, that's just an additional asset that you can get more cash for, I guess, at the end of the day. But it's all about commercialisation. If you're going to get a patent, we all know they're quite expensive, so you are going to want to commercialise that, and it's a leverage position. So when we're looking at patents, patents are both a legal and a technical document, and you get 20 years worth of protection and a monopoly right. And there's quite a few thresholds that you need to overcome in order to get a patent granted, but I guess the main two here are new and inventive. That's what your invention has to be. So in terms of novelty or newness, we're talking about you can't have sold it or used it before, and you can't have published any results on it as well. And that's not just Australia, but that's worldwide. In terms of inventiveness, what we like to see is that, it wasn't obvious to someone else in your skilled area. So, for example, if you were to spray chemical X on your crops and you anticipated that you were going to get result B, and in actual fact you got result Z, then that's surprising and unexpected. And that's the type of results that we like to see, and that would probably get you over the inventiveness threshold. I've just got a couple of examples there. John Deere's got patents around agricultural harvesters, BASF, who's actually a client already with Watermark, and they've got fantastic portfolios around insecticides and gene modifications. So just switching gears a little bit, trademarks. I actually gave a presentation at last year's convention through the Export Symposium, and I spoke about, locking down your trademarks, getting sorted for export markets. So a trademark, which you probably all know, is used as a badge of origin to distinguish yourself, the goods and services from one trader from another. And you can get a trademark for words, shapes, colours, sounds. You can even get trademark registered for smells, so a scent. So on the register, eucalyptus is actually registered. And that enables you a 10-year term of protection. That is renewable, so you can have it for a lifetime as long as you pay your fees. And I've just got some examples there. So, the script writing for the Pink Lady apples, or Four Ways Fresh, we're actually helping them out getting their trademarks sorted both nationally and internationally. And this is actually one of my favourites. So the bananas on the end there, the trademark is actually in the wax that they've dipped. And so the trademark consists of the colour red, green and blue as applied to up to 1/3 of the banana. So that in itself is a trademark. And someone very cheekily tried to infringe that by changing the colour to purple. But don't worry, they got in a lot of trouble for that. In terms of trademarks, what we like to have a chat to clients about is, are you export ready? And in terms of that type of thing, things you need to think about are different countries have different rules. So with trademarks, it can be a first to file ruling or it could be a first to use. And what I mean by that is if you're, for example, China, Japan, Indonesia, Thailand, they have a first to file. And we have seen this numerous times, and this is not a scare tactic at all, but just to, the reality is we've had a client, they've gone to a business meeting in Indonesia, they've exchanged business cards, and someone's gone, "Ooh, that's a nice logo." And they've gone, that person wants to import their product here. And that person has then gone and filed a trademark, and it could be yours. Because it's a first to file ruling in that country, they then become the owner of that trademark. In comparison, it's a first to use here in Australia and places like Malaysia. And so if you've been using that trademark, no one else, well, typically no one else can register that trademark. So those are the types of things that we are encouraging people to become aware of, especially if you're going to export your products. PBRs, plant breeders' rights. Obviously, there's quite a lot of interest in this industry around that. 2 types of terms, so 25 years for trees or grapevines and 20 years for the other species. And the exclusive rights you get around that are, quite a lot. So, producing and reproducing the plant material, conditioning the plant material, not just selling the plant material, but offering to sell the plant material. And of course, importation and exportation. This is something that we very much encourage. You need to think about whether you have a freedom to operate. Obviously, patents, trademarks, designs, things like that, they're quite expensive to get one. And so you don't want to be halfway down that road and then realise, oh, hold on a minute, guys. Do I actually have freedom to use this logo that we've just spent a $200,000 marketing budget on? Or can I actually use that plant variety in that country because I've just imported into there? And you need to think about that not only in Australia, but the export markets of interest as well. And so we have a specialised team at Watermark that does searching and freedom to operate searches. And that can assist you in identifying potential roadblocks before you actually get to there. And I can tell you right now, for the cost of filing a trademark versus the cost of working out that your stock is on the docks in Indonesia and customs won't let it in because they know that your trademark looks very similar to someone else's trademark, it can be a very costly mistake, and it happens. In the IP searching, we can not only identify your competitors, but we could actually identify some collaborators as well. So if you need to fill a void, that's also a useful tool. Why would you engage with the team at Watermark? Well, we have a very expansive international network. So like I said, if you need to find out whether you've got freedom to operate and use that trademark or logo in Indonesia, we've got people on the ground who can assist with that. We're experts in IP strategy, so we're not just lawyers, general lawyers. This is our thing, this is what we do. We specialise in intellectual property. And with that, we have cost-effective outcomes. We look at the whole portfolio. It's not tunnel vision at all. And as I said, patent and trademark searching, and we can assist you with renewals and licensing. Thank you very much. I'm just going to pass over to Richard now, and Russell, and he's going to talk about the R&D tax incentive.